My name is Judge Lebo. Let's hear the appearances from the attorneys.
Josh Larman, Your Honor, on behalf of the people of the Northern District of New Orange.
Okay, hang on one second. So for the people, you have Josh Larman, you said?
Yes, Your Honor.
And also from the prosecution?
Your Honor, my name is Alejandro Ocasio, also on behalf of the people of the Northern District of New Orange.
Okay, thank you. And for the defense?
Good afternoon, Your Honor. My name is Joshua Fitzgerald. I'm with the defense and I'm here with my co-counsel.
Good afternoon, Your Honor. My name is Dara Broadnax, and I'm also here with the defense.
Okay, great. Do we have any housekeeping?
Yes, Your Honor. The people, as far as objections go, would Your Honor prefer?
Prosecution, any housekeeping?
Yes, Your Honor. As far as objections, would you prefer objections with grounds, or objections with grounds and argument?
I would like objections with grounds. We'll go from there.
Okay, thank you, Your Honor. And then with respect to objections also, should counsel respect or ask to be heard outside the presence of the jury?
You can assume if you object, we're outside the presence of the jury during the argument.
Okay. And Your Honor, once an exhibit is admitted into evidence, should we ask or request for that exhibit to be published to the jury?
Yes.
Okay. The people have no further housekeeping matters, Your Honor.
Anything from the defense?
Yes, Your Honor. The defense just has one housekeeping matter. We noticed in preparation for today's trial that there was a slight delay when we go to publish exhibits using the screen share function, an unfortunate side effect of Zoom court. We just wanted to bring that to the court's attention in advance, let you know we're publishing these as fast as we can get them up. This just seems to be something out of our control, and ask for your indulgence in advance.
Thank you for letting me know. Anything else?
Your Honor, the people have one other matter to raise with the court at this time. As part of our pretrial conference, both parties shared any demonstratives that might be used in this trial. The people have some concern over a couple of demonstratives that have been proposed by the defense, and we would like to know how you would like to handle that, or if that's something you would like to discuss now, or if it's an issue that should be raised once those exhibits have been offered and accepted.
Let's address it when we get there. Your
Honor, if I may, there is one demonstrative that was brought up, and this demonstrative is used during closing argument. If we can, I would like to discuss it now. That way, during closing arguments, we don't deal with an objection to impede the flow of trial.
All right, what is it? What's the demonstrative?
Your Honor, the defense intends to essentially zoom in to the exact lettering on two separate exhibits, those exhibits being B and C. These exhibits are essentially handwritten notes from different parties that are alleged within this trial. And the people believe that in viewing that kind of evidence out of its context would be improper and would be prejudicial to some degree.
Your Honor, there will be evidence elicited throughout this trial to show that Exhibit C, the grocery list, was written by one of the witnesses, Riley Jasper Walker. There's also the ransom note in this case, Exhibit B, that was collected from the house. We are showing these exhibits side by side during closing argument. Throughout the trial, we're going to elicit testimony and evidence to show these two notes have the same author. And as such, during closing, we are going to show the lettering is the same, the ink color is the same, just to further make our argument before the jury so that they can make that determination.
All right, I will allow you to show a demonstrative that includes a blow-up of any exhibit that is received into evidence at the trial.
Thank you, Your Honor.
All right, that was kind of a motion, so let's kind of continue along that line. Any further motions from the prosecution?
Yes, Your Honor. The prosecution has two motions in limine.
Go ahead.
Sure. The people anticipate that the defense will call Dr. Alex Dixon to the stand to testify as the psychiatrist of the defendant, an alleged psychological condition that the defendant has. The people would move to exclude any opinion of Dr. Dixon's on the ultimate issue of whether the defendant was able to form the requisite state of mind to have been guilty for this offense. And we would move for that under Rule 704B of the Federal Rules of Evidence.
Response?
We have no objection, Your Honor.
Motion granted.
Thank you, Your Honor.
Your Honor, the people have one additional motion. It's also in relation to the expected expert testimony of Dr. Dixon. At this time, the people move to preclude Dr. Dixon being offered and admitted as an expert in criminology and crime scene investigation. This is just based on the fact that Dr. Dixon has not practiced crime scene investigation in some 29 years and has been totally absent from the field. Under Federal Rule of Evidence 702, subsection C, expert testimony requires that the testimony is the product of reliable principles and methods. In this case, given Dr. Dixon's absence from the field, it's impossible for him to be up to speed on what those principles and methods would be. And for those reasons, we would preclude such expert testimony in that capacity.
Any objection?
Your Honor, opposing counsel brought this up with us during pretrial. We indicated that we would be willing to stipulate to it. However, counsel wanted to make their argument. We, again, have no objection to this. We don't intend to offer them as an expert in crime scene investigations.
All right. I'm wondering if you think that all the law professors that haven't practiced law in 25 years could be considered experts in that field of law. But that's a discussion for another day. So without objection, the motion is granted. Any further motions from the prosecution?
No, Your Honor. Those are our two motions in limine.
Very good. Defense motions?
Yes, Your Honor. The defense has one motion. But first, by way of background, we would like to explain that Mr. Walker is being charged with killing his daughter. We have brought forward an affirmative defense of not guilty by reason of insanity. However, we still fully intend to show that the prosecution cannot prove their case beyond a reasonable doubt. Our first motion is actually to exclude any mention of a Thanksgiving incident that took place prior to Claire Walker's death. By way of background, during this Thanksgiving incident, Morgan Walker, the defendant, allegedly blacked out due to anger. And when he came to, his daughter Claire was on the ground crying. Now, the prosecution may say that Morgan Walker got so angry that he harmed his daughter. In the current allegations, it is Morgan Walker got so angry he blacked out and killed his daughter. Now, these two incidences are undeniably similar. It is the same people involved, same conduct, same anger problems. The only difference is now the prosecution is alleging the outcome was the death of Claire Walker. For this reason, it should be excluded under 404B, as it is being used to show a pattern of behavior.
Response?
Yes, Your Honor. So the prosecution does want to talk about Thanksgiving, but not for the forbidden propensity evidence that the opposing counsel just mentioned, but under Rule 404B, the permitted uses, we would seek to elicit this testimony as far as absence of mistake in the alternative common scheme or plan, given that it is the theory of the defense as an affirmative defense that Mr. Walker is unable to remember when he blacks out, that this goes to the defendant's pattern of covering up potentially bad acts in the way of using this diagnosis as an explanation or an excuse for what he has done. And so we would not be offering it to show conformity therewith as far as character evidence. We'd be offering it for the permitted purpose under 404B2. And in the alternative, Your Honor, I would also say that 404A3 permits the usage of character evidence to show for impeachment purposes. And so there is a truthfulness element of this as well, given that the defendant did explain what happened, although he claims not to have known what happened at the same time. And so for that basis, we would also oppose the motion.
Anything further from the defense on this particular motion?
Your Honor, we also raise grounds of 403. Any mention of this would be unfairly prejudicial, and that risk would substantially outweigh any probative value. No one knows what happened while Morgan Walker was blacked out during this Thanksgiving incident, and as such, the jury would be led to speculate as to what happened. And we also have to remember this is a case where the deceased is a young child. There's already going to be some level of emotional toll on the jury that could be exacerbated if they hear any evidence implicating that Morgan Walker may be abusive to his child. As such, under 403 grounds and 404B, we believe this should be excluded.
Your Honor, may I be heard as to the 403 grounds?
Yeah, briefly.
Sure. The prosecution maintains that the potential unfair prejudice would be outweighed by the probative value of this evidence, given that it was an event that we anticipate will be drawn out, that the defendant thereafter sought out psychological services. And so it's highly relevant under 404B, and so that would outweigh its potential prejudice. And we would be amenable, I should say, Your Honor, to a 105 limiting instruction so that it not be considered for propensity.
Tell me one more time exactly what testimony you'd like to elicit regarding this incident.
Yes, Your Honor. So on Thanksgiving, this would appear in the defendant's voluntary statement. On Thanksgiving, the defendant got allegedly lost his temper, blacked out. When he came to, his daughter, Claire Walker, was crying on the kitchen floor. Aaron Jasper Walker was also present at that event, and the defendant can't account for what happened. Although after he did tell his wife, or his husband rather, Riley, that Claire had fallen out of the chair. That's the truthfulness element. So that's the event that we're speaking about.
Your Honor, may I just speak real quick and respond to that?
Last thing, real quick.
Yes, we would be willing to offer a compromise. The main prejudicial aspect of this is the aspect about Claire Walker being on the ground crying. That's where all the speculation comes in. If they want to offer it to show there was a prior incident where Morgan Walker blacked out due to anger, and that's why he had to go see a psychiatrist, we would be completely fine with that. We would be open to that compromise. It's just that speculative period, that gap where we don't know what happened. That's where we take issue.
Okay. I like that compromise. So let's leave the part out about the girl, about the daughter. You can get into the rest.
Understood, Your Honor.
Any other motions from the defense?
Yes, Your Honor. We have one more motion. We would ask that any mention of Morgan Walker putting his daughter Claire Walker into boarding school be precluded as irrelevant.
Does the prosecution intend to get into that?
Yes, Your Honor, the prosecution does intend to elicit testimony about the victim's prior history. We think it's not only important to outline for the triers of fact in this case, the past of the victim in this case, but furthermore to elicit testimony that speaks to the relationship between the defendant and the victim. And that relationship is both is spatially important and relevant, and also is relevant as far as considering the actual kind of material relationship between the two in this case. And for those reasons, we would ask that that piece of evidence, that testimony, not be precluded.
Why should this testimony be kept out?
Your Honor, as we stated, this is irrelevant to these proceedings. It is such a far-off event before the case at hand. And we would also bring up under 403 grounds. Again, this would be the risk of unfair prejudice is great with this and substantially outweighs any probative value the prosecution might get. In reality, Morgan Walker put his daughter Claire into boarding school because he has a hectic work schedule. He has the atypical job. Jury may hear this and think that it's because he had some animosity. It was a bad relationship. In reality, he had no choice. He has a work schedule. He couldn't care for his daughter. He had to just put her in boarding school. So there is that risk of unfair prejudice.
Your Honor, may I respond briefly?
Oh, that's all right. I'm going to deny the motion. You can explain that through testimony if you feel a need. Any further motions?
Your Honor, could I just have clarification as far as the compromise, the partial granting of the defense's motion? So just to be clear, the people are permitted to talk about Thanksgiving. Just testimony can't be elicited as to the victim in this case crying and being on the kitchen floor. I just want to make sure I understand that correctly before we begin.
Is that an accurate representation of the compromise you offered, Counselor?
Yes, as long as there's no mention of Claire in any of the testimony being on the ground crying, any implication that Morgan harmed her during this incident, we were fine with that compromise. We would also ask the prosecution be precluded from mentioning Claire if they have it in their opening statement.
Well, they can't mention her in that context. There may be other relevant ways to mention her, but Mr. Larman, your understanding of my ruling is accurate.
Thank you, Your Honor.
Okay, we ready to proceed with opening statements?
Yes, Your Honor.
Yes, Your Honor.